Good morning, everyone. We'll just wait a few moments for people dialing in. There's usually a 10-20 second delay, and then I'll briefly introduce myself and the session. So as we're waiting for people to dial in, for those who don't know me, my name is Mario Machado. I'm the National Practice Leader of the Health and Safety Department at Aon Australia, and I'll be chairing today's webinar on work health and safety due diligence and the new industrial manslaughter laws. Just some housekeeping with regards to the session. The session is being recorded. You'll be able to access the webinar through our Aon Insights website in the next couple of days. You've joined in on listen-only mode. You'll be able to ask questions throughout the presentation using the questions window on your control panel. But just given how many people are dialing in today, we've got over 630 registrations. It's unlikely we'll be able to get through every question, but we'll do our best to try and consolidate that over the next 60 minutes or so. But you know, feel free to pose questions for any one of us over the next 60 minutes. So hopefully everyone's sort of dialing in now, so what I'll do is I'll introduce to you our presenters. Aside from me, Trent Sebbins is joining us from Ashurst, Australia. He's a partner with a significant amount of experience in both employment law and work health and safety law. He'll be talking to us about, obviously, industrial manslaughter and due diligence, followed by Kerry Wright, who's one of our colleagues and works in the what we call the fin lines, the financial services lines, and heads up our commercial aspects of that, and has a lot of experience in dealing with work health and safety work health and safety insurance, which is something we're going to be talking about today. And Angela Messi from Liberty, who also has quite a lot of experience in dealing with work health and safety insurance, which is one of the things that we're going to be talking about today. So again, thank you for joining us today. And really what we're focusing on this morning is really expanding on the narrative that we've all been talking about recently in the last couple of years around industrial manslaughter and the relationship with due diligence, which is in most of the states a positive obligation on officers to exercise due diligence. So we'll be talking a little bit about that, providing an update on exactly what industrial manslaughter means for organisations, and providing a bit of context as to how we even got in this place. And we'll also be talking about insurance and the relationship between insurance and health and safety, which is something, well, there's been a range of changes with regards to that as well, and we think it's really important that we explain what that is and what it looks like. So I guess why we're talking about industrial manslaughter and why was industrial manslaughter legislation introduced, or why is it being introduced? And it really comes back to the Ballon Report, as we call it. The Ballon Report was a review of the model work health and safety legislation, which was undertaken in 2018. The review made 34 recommendations, 2 of which we're going to be discussing today. Industrial manslaughter was one of the key recommendations that came out of the report. The recommendation came off the back of growing debate around making personal liability a key factor in legislation. Research shows that personal liability is a key lever in increasing work health and safety ownership in organisations. The other reason industrial manslaughter was recommended in the report was to place greater emphasis on harmonisation of laws, because at that point Queensland had just introduced industrial manslaughter and the ACT had it for a number of years. So it was really in the interests of harmonisation that these recommendations have been made. So hence why we've been seeing the ongoing expansion of these laws across the states. So where we find ourselves now is that Queensland, of course, and the ACT have rolled out these laws. Victoria have rolled out industrial manslaughter legislation along with Northern Territory, and Western Australia have assented the Act with industrial manslaughter, but we're just waiting on the rollout of those laws once the regulations are drafted. So soon we're going to find ourselves with industrial manslaughter in most states of the country, with exception of New South Wales and South Australia and Tasmania. So in many ways, what we've now got is a set of, in many ways, unharmonised set of harmonised laws. When you think about harmonisation started in 2011, 2012, and now we've got, in some ways, a mishmash of different laws in different states that look slightly different to all others. So that's something that, of course, is confusing for large national employers and even for small organisations alike. This is something that Trent will be sort of talking about in a very brief way, just to provide some clarity around what these changes actually look like and what the differences are in the states. So as we approach the session itself, there's a couple of things I perhaps want you to think about, because ultimately health and safety changes and the industrial manslaughter laws are designed to improve work health and safety in the workplace. So I just want you to think about, well, off the back of what we're going to be talking about, does industrial manslaughter legislation make workplaces safer? And if you think it doesn't, what could you do differently within your organisation to ensure that that happens? Do these laws drive the right behaviours, both at a senior level and perhaps even at a lower level? And do industrial manslaughter laws reduce or enhance positive obligations on officers to exercise due diligence? So in other words, do these laws drive the right type of changes that the model laws are intending to? So it's important that we think about that, because when you consider the feedback that we get from our clients and our organisations that we work with on a daily basis, and even look at insights from our last risk survey. So the global Aon risk survey that was done in 2019, we do them every 2 years, highlighted of the top 10 risks that our clients gave us feedback on, 4 of them more or less relate to what we're talking about today. Of course, when we talk about industrial manslaughter or changes around obligations on officers, it's not always about penalties. That there's a whole range of other impacts around damage to reputation, business continuity, and the like. So it's really important that when you consider some of the things that we're going to be talking about today, it's not just about financial penalties and even in jail terms, for example. There's a whole range of other things we need to be thinking about. And this report, which you can access online, shares some really interesting insights, because this is the feedback that our clients are giving us about what is important for them from a risk perspective. But certainly our experience so far is that industrial manslaughter is very much on the agenda of boardrooms, and there's a lot of officers across the country that are keen to learn more and more about it. The other thing that we're going to be talking about today, and I just want to bring to your attention, which is one of the other recommendations from the Ballon Report, was around the prohibiting of health and safety insurance products that cover financial penalties. So, and there's perhaps a little bit of ambiguity around what that means. These laws have already been rolled out in New South Wales and will be in Vic and WA, expecting that other states will adopt these laws. So it's really important that as safety managers, and for those who aren't necessarily safety managers but have a broader ownership around health and safety, it's important that we understand exactly what these insurance changes are, because insurance is a really important part of the overall equation when we think about risk management. It's not just about managing health and safety, but having insurance solutions that are in place to manage critical incident is really, really important. So we'll cover that off a little bit later on. So with this in mind, I'll hand over to Trent shortly, who is going to give us an overview of what does due diligence look like when we talk about the model laws and the states that have got them, and then specifically industrial manslaughter. Over to you, Trent.
Excellent. Thanks very much, Mario, and good morning to everyone. Thanks for joining us on this important topic. You've no doubt seen in the press over the last 18 months to 2 years that there's been a lot of talk around both penalties which are built into the harmonised work health and safety laws, the increase of those penalties across the states and territory, but also the implementation of new industrial manslaughter offences, really to send a clear message to businesses and their officers that safety needs to be critical and also that it can have very serious effects upon an individual's liability, including a custodial sentence if you fail to meet your duties. So it's worthwhile, I think, in that context to just refresh ourselves about what is the officer duty, and I'll go on to then explain due diligence as well as then talk about the industrial manslaughter provisions in particular that have been introduced across various of the states and territories. So just recapping then, firstly, on the officer duty, you'll see on the slide in front of you on your screen that it is a standalone duty. It's typically in Section 27 of the Model Work Health and Safety Act across the states and territories. And it effectively tries to pierce the corporate veil by accepting what is quite obvious, that is that a person conducting a business or undertaking, usually a corporation, acts through its officers and also other persons. And so to ensure that the PCBU meets its own duties, it creates a standalone duty for officers to ensure that they are making sure the PCBU meets its duties. So you'll see there the three elements. If the PCBU has a work health and safety duty or obligation, then secondly, each officer of that PCBU must then exercise due diligence. And thirdly, that due diligence is to ensure that the PCBU complies with its work health and safety duty or obligation. Now, that's a standalone duty. It does not require the PCBU necessarily to be engaged in a contravention, but of course, we see that that is the usual focus where we are seeing cases. There are no cases so far where there's been a prosecution just of an officer in the absence of a PCBU or corporation. So that's the usual focus of analysis, but it is worthwhile to think of it as a standalone duty that endures regardless of what else is happening in the business. It does require officers to be very active, indeed proactive, and they must turn their minds in a critical way to safety in the business, how it's being achieved, and also how it's being resourced. You may be aware that the definition of officer is effectively borrowed from the Corporations Act. We won't go into that, but very senior officers as well as directors, so the executive leadership team and the board, of course, will be officers, but possibly at lower down levels as well. So that due diligence obligation then has 6 elements, and it follows effectively a life cycle type approach to work health and safety within a business. I won't go through each of the elements with you, but you'll see that sort of life cycle. That is acquiring and keeping up to date knowledge about work health and safety generally, understanding the business and the hazards, and then some sort of assessment both of the risks that arise from those hazards and the systems in place to control them, and then ensuring that incidents are responded to in a timely way, that there are sufficient resources, and then an ongoing verification step. There isn't much case law on what due diligence means at this point in time. There is one case in the New South Wales District Court, which is the case of Safe Work New South Wales and Hetherington, which is a decision in 2019. And what it considered was whether or not the charge laid against the particular officer in that case was a valid charge or not, and whether or not the proceedings should be stayed. Ultimately, the court upheld 4 of the 6 elements or particulars of the charge and rejected 2 of them. And in considering that, it turned its mind, that is, the judge turned his mind to what amounted to due diligence. And just by way of some brief commentary from the judge, he focused on a couple of things. Firstly, in the introduction of the section in New South Wales, there was a expert report by Stewart and Compton, and they said that that provision required officers to be proactive about ensuring compliance by the company and then making the officer liable for their own acts or omissions in that regard. So it intended that it required proactive steps. That was critical to the judge in his reasoning. Secondly, it required the officer to take reasonable steps to achieve the objectives which are set out in the section. And the judge accepted that while those elements, which you'll see set out on the slide, are certain aspects of achieving due diligence, that definition is not closed. And he referred to the context of the Corporations Act as having defined a similar concept as establishing a minimum standard of behaviour involving a system which provides for a system against contravention of regulatory provisions, and also requires adequate supervision, ensuring that the system is properly carried out. He emphasised in particular that it must not be just simply a paper system and that the officer is just paying lip service to the duty. Further, there were some examples by previous cases from predecessor legislation, which his honour referred to, and that included commentary in those decisions about sufficient due diligence for directors, including addressing safety matters at board meetings, and one might suggest also at executive leadership team meetings, which that would then require managers to report up to the board or the leadership team on safety matters, and then permit those officers participating in those meetings to monitor safety. And then lastly, his honour noted that the exercise of due diligence and what are reasonable steps will be determined to some extent on the officer's place in the corporate structure and their ability to control the objectives which are outlined in the section. So while, as I say, there's not much case law on due diligence, there is some guidance there. We also have the ACT Supreme Court decision in respect of Al Hazani and Kenos Constructions, although again, really not being all that illuminating on what due diligence is. But what it clearly contemplates is that there is a plan which is put in place by the officer and that it covers off on those elements, if not more, in order to ensure that the PCBU meets its objectives and also its work health and safety obligations. So there are some practical steps, and you will see those on the next slide, which we suggest that a PCBU, but also together with the officers that are identified, can undertake. So the first of those is to identify who are the officers. I'd suggest you don't be overly narrow or overly broad in undertaking that process. It is easy to just assume that it is only the board and the executive leadership team, but for certain organisations, you would expect that it does descend down to lower levels. And it is also quite possible that certain executives are not officers, depending upon what role they play, as has played out in various cases on other provisions under the Corporations Act, where it's being considered that possibly those who only give advice, perhaps those in support or functions, may not amount to being officers. So undertake that activity, identify who might be officers, but don't be too narrow or too broad about it. Secondly, develop a due diligence action plan for those officers. Now, I've said that the obligation is a standalone one for the officers, and that is correct, but that doesn't mean that the individual must develop their own bespoke due diligence system. It certainly is a system that the person should be actively involved in, should take an active participation in, and perhaps some level of ownership. But it doesn't need to be the case that every single officer has their own individual due diligence system. It's entirely permissible for officers to have a shared due diligence arrangement as long as they are active participants in it and not just passengers in the process. Critical is the third step, which is to implement that due diligence action plan. So in accordance with that Hetherington decision and the cases that it referred to, it's not sufficient that there be just a paper plan or just lip service. The plan must be implemented, it must be monitored, and it must be enforced. And if that includes that the officers have determined that others will undertake certain steps for them and report back to them, that those steps are ensured to be taken and are followed up. which leads lastly to the fourth step, which is to regularly check and verify the plan. It's useful for officers in the decision-making organs of an organisation to have regular checkups. That could be in a board meeting or in the executive leadership team meeting or in other operational team meetings to ensure that that is the due diligence check is on the agenda at least once a year to make sure that the system is operational and is being both implemented and reinforced. So with those things in mind, let's then turn to the industrial manslaughter provisions, which we've seen have been implemented across various states and territories over the last few years. As Mario has said, there is a wave of reform which has occurred across the states, ACT being the most recent one to have taken the further step of changing its laws. It was the first jurisdiction to implement industrial manslaughter laws way back in 2003. Those provisions were very rarely, if ever, used, other than in relation to a most recent case that's still working its way through the ACT courts, which involved a crane rollover at the Canberra University Hospital. We've seen, though, in the last 2 years in particular, Queensland in 2017, the Northern Territory and Victoria in 2019, WA most recently in 2020, but hasn't yet implemented the laws until it implements its regs, all implement industrial manslaughter laws, and New South Wales certainly turning its mind to that issue, but deciding not to change its laws other than to include a particular provision that makes reference to the provisions in the Crimes Act concerning industrial manslaughter applying. You'll see on this slide that there are a number of elements to the industrial manslaughter laws. It's probably best to think of the industrial manslaughter laws as offence provisions that relate to effectively an aggravation of the offence. So there are the standalone duties that we've talked about. Obviously, the PCBU will have its own duties under the general duty in section 19 and other provisions, as well as officers will have their own duties. Like the category 1, 2 and 3 offences that then add on to a breach of the general duties or the officer's duty. Similarly, most of these industrial manslaughter laws then add on to the breach of that duty. And it applies, you'll see in the center of the screen or the slide, in a particular way. It attaches generally to PCBUs across most of the jurisdictions, noting that in Victoria and WA as the law currently stands, it doesn't use that concept, but let's just borrow that for the moment. And then it applies also to officers. In Queensland, only to senior officers, but in all the other places to officers in the general use of that term. So that's the first element, who does it apply to? And then secondly, it requires that a worker dies in carrying out work for the business. Some of the laws go further than that and refer to a worker passing away from injuries or an illness that might have been sustained. So it may not involve a fatality that occurs on a site, but it contemplates the possibility that a worker may pass away at some later point from their injuries, and it captures those circumstances as well. The most critical things are then the second, or rather the next two items, which is the conduct causes the worker's death, or there's a breach of statutory duty. You'll see the differences there across each of the states, or the cumulative effect of them. And in the Northern Territory, a element of intention, these being criminal offences of a breach of statutory duty. And the last being perhaps the most critical of all, that is that conduct is either negligent or reckless or negligent, or there is knowledge of likelihood of death or serious harm which has been disregarded, or again, there's neglect or consent or connivance. So each of the states and territories do take a slightly different approach to this. As Mario said, the idea of the harmonised laws commencing in 2011 was that there be a national framework adopted across all jurisdictions. We are unfortunately in this way starting to see a disparity in the way in which industrial manslaughter laws are both being developed and also how they operate. as well as a difference in relation to the penalties that attach, which is the last item you'll see there on the screen, which I'll elaborate on in a moment. The test there in respect of both recklessness and negligence does also vary across the states and territories, in some places borrowing on the criminal concept of negligence and recklessness obviously being developed already at the higher category offences already that exists under the work health and safety laws already in place. So let's then have a look at the penalties. You've got a snapshot briefly there on that slide, but to set them out in some more detail, remembering New South Wales does not have standalone work health and safety industrial manslaughter laws, you'll see the very significant custodial sentences that can be implemented or an individual can be convicted of, as well as pecuniary penalties. And here we've set out the individual penalties. For corporations, those penalties can be substantially higher. What that does demonstrate, and we certainly are seeing this in practice, is that there is a willingness to convict individuals of offences and then to issue custodial sentences. And we have seen so far over the last few years in the various states sentences for imprisonment, most often suspended sentences after an officer has been found guilty of recklessness or gross negligence. So far, we have not yet seen a conviction for an individual or an officer under the industrial manslaughter offences. We have, and you'll no doubt have seen these in the press, we have seen various imprisonment sentences issued, one in WA most recently in May, which was a sole director of a company called MT Sheds, where a worker had been blown off a roof. He was then convicted of 26 months imprisonment and required to serve 8 months of that, with the rest being suspended. In 2018 in Victoria, an officer being sentenced to 6 months jail in respect to a scrap metal business and someone being crushed by a bin falling from a forklift. And in Queensland, I'll come to another example in Queensland, but in 2019, a sole director, again in relation to a roof fall where there was no safety rail installed, that sole director being convicted of recklessness and sentenced to 12 months jail, although that has been set aside on appeal because of a misdirection to the jury and a retrial has been ordered. Now, in all of those cases to date, they've involved smaller companies, usually in higher risk workplaces, such as in construction or where there is mobile equipment, which has resulted in crush injuries and fatal injuries being sustained. The officers charged have been very hands-on in most of those cases and directly involved in day-to-day activities of the companies. And it's been quite clear on the evidence that the failings of each of the directors has directly contributed to the deaths of the persons to whom the duties were owed. The cases, though, do highlight the increasing custodial penalties that can be imposed on officers who are reckless or grossly negligent. And we wait to see how those trends, if I can describe them in that way, might lead to the prevalence of industrial manslaughter charges being laid and then officers being convicted and sentenced to custodial sentences or significant financial penalties. We've certainly seen in Queensland in the last few weeks announcements about a director of a sugar company being charged with an industrial manslaughter offence, and I think even last week a couple of additional examples of directors again, I think in relation to an electrical incident in Queensland, again being charged with industrial manslaughter offences. So certainly something to watch this space, particularly in those jurisdictions where regulators are very active. Perhaps in Queensland, given the laws have been in place since 2017, we are starting to see the regulator starting to be more willing to use those provisions. So by way of a couple of brief snapshots on that front, let's have a look at the case of the prosecutor and Brisbane Auto Recycling, which was a decision of last year. It is the first exercise by the court and also by the prosecutor of a conviction of a company for breach of the industrial manslaughter laws in Queensland. In that case, Brisbane Auto Recycling was convicted of the industrial manslaughter offence and fined $3 million. That is around about a third of the maximum penalty for a corporation under industrial manslaughter laws. Importantly, the two relatively young directors who operated this auto recycling business were also then charged, although charged with the lesser offences, although the most serious ones other than industrial manslaughter, and ultimately convicted of those involving recklessness and sentenced to 10 months imprisonment, but the whole of those sentences being suspended. In that particular case, the incident involved a worker who was using a tilt truck tray, delivering a scrap or a vehicle to be recycled to the yard, being then crushed between the vehicle as he was moving around it and a forklift being operated by another worker who was moving some other items on the site, and who then suffered fatal injuries. Most significant in this case was almost the complete absence of work health and safety systems which were in place. As I say, the directors were both young. They were also immigrants who had come to Australia within the previous few years before they started to operate these businesses and the incident then took place. They had a quite low level understanding of what safety requirements were required, including in relation to both systems, but also then other measures that ought to be implemented, particularly around the use of forklifts. For example, the individual who was driving the forklift and who unfortunately reversed into the deceased was not licensed to operate the forklift. There were no traffic management systems which were in place, no exclusion zones which were set up, and it was a very unfortunate and tragic incident from just a complete lack of work health and safety systems having been adopted. So the recklessness as found in that case, although obviously on a plea, was quite easy to be satisfied by the court, and you'll see, as I've mentioned, the individuals then got sentenced to 10 months imprisonment. Unfortunately, not much can be taken from the case in respect of due diligence and how that intersects with the offence provisions, but worth noting certainly the way in which the regulator is prepared to lay a charge of industrial manslaughter, including against PCBUs. I suppose it's possible in this case that they could have laid the charge similarly against the directors, but chose not to do that. It's not clear why that choice was made, but certainly might have been open on the facts. One other case worth mentioning, and I've mentioned it in passing, is the case involving Canberra Hospital, that is the Canberra University Hospital, in which there was a rollover of a crane which was lifting a transformer, very heavy transformer on the site. There were charges which were laid against a whole range of entities, in that case RAR, which was the crane company, and Multiplex, which was the relevant principal contractor on site, as well as a range of individuals. The principal contractor and subcontractor got charged with a recklessness offence, but also then various officers and workers were also charged. Amongst them, and this is the one which has got most attention so far, was the crane operator. In that particular case, the crane operator was a casual employee, was operating under instructions, but the court was satisfied that the worker ought to have raised his concerns that he clearly had about the capacity of the crane to undertake the lift and the manner in which it was about to be undertaken. Ultimately, the lift was beyond the capacity of the crane and it tipped over and the boom struck another worker, and unfortunately he was killed. And the crane driver in this case was ultimately sentenced to 12 months, but that sentence was then suspended. Other officers, other workers and officers were also then prosecuted. It has turned out to be the case that the prosecutor has now withdrawn charges against some of those officers. One of them was the CEO of Multiplex, another was the site manager of Multiplex, and another the health and safety representative of that company. The prosecutor has withdrawn the charges because it was considered that there was insufficient evidence to be able to take those prosecutions to ultimate conviction. It's unclear where the other individual prosecutions currently lay, because there were some others in respect of the managing director of RAR Cranes and some other workers. So worth just paying attention to that if there is still anything yet left to be done. But I suppose the critical message here being the readiness of prosecutors to lay multiple charges both against workers and officers who failed in their duties. Obviously, in this case, the charges laid against the officers because they hadn't met their due diligence obligations, but also then PCBUs at various levels, principal contractors and their contractors, where there are serious incidents which have extremely serious outcomes, including workplace deaths. Some critical lessons there then. Let's perhaps move on to our next topic. I'll hand back to you, Mario.
Thank you, Trent. You've touched on a whole range of issues, and but you said one thing that I think is really important. That is, when you look at all the sort of key cases so far, probably with the exception of the last one that you mentioned, they all involve small companies. So often when we're talking to clients who are small businesses, there's often a feeling that these laws relate to your large organisations, but in reality, it's a lot of the smaller businesses that are being prosecuted. It's not to suggest that large organisations are sort of void of this risk, but certainly this is something which applies to medium and small businesses as much as large organisations, and in many ways, perhaps they're even at a higher risk of because they don't necessarily have the resources to manage this to the same extent as large organisation. But certainly with what you said there in terms of the regulator willing to enforce these laws, because there's plenty of examples now, it really will be interesting to see how the next couple of years goes in terms of large organisations. So thank you, Trent. And in many ways, this is it's a nice segue into the next section around understanding risk management and insurance, and this is off the back of the changes to the recent laws around the prohibition of insurance products to do with paying of penalties. But so it's really important that we understand, firstly, what are all these different types of insurance products and what do they do, and how relevant were they in the first place? Because we know that there's exclusions around criminal offences in the first place. So I'll hand over to Kerry, who's going to take us through this first element of the insurance, and then we'll hand over to Ange. Over to you, Kerry.
Thanks, Mario, and thank you everyone for your time this morning. From an insurance or risk transfer perspective, there are a couple of policies that can provide companies with assistance if and where purchased. The first is a directors and officers liability or management liability policy, which are designed to protect directors and officers in the event that they're sued for actual or alleged wrongful acts in their capacity of managing the company. The second, which is the bigger piece, is the statutory liability policy, which, depending on the policy wording, can also have an additional WHS extension, which provides broader coverage. This protects the company, senior management and employees for allegations of wrongful breaches of key legislation in the course of carrying out the company's business activities. Insurers will provide cover in respect of investigations and defence costs, as well as penalties, if permissible by law. So if we can move to the next slide. As Mario touched on, the key thing to note is that manslaughter penalties are and always have been uninsurable. Even when there is no ban on providing insurance under the current legislation, criminal behaviour is uninsurable by law. Only certain strict liability offences, such as Category 3 offences, may be insured. investigation and defence costs may be advanced up to the point of conviction. So if we can move on to this next slide. Irrespective of if a company has a policy in place that could afford them coverage, it's critical to act quickly in the event of a serious WHS instance. The broadest WHS policies don't require formal notification of investigation from a regulatory authority, which means that the policy is triggered immediately from the time a serious workplace injury or fatality occurs. This basically allows policyholders immediate access to the investigation, defence and crisis costs to assist with building a defence, utilising lawyers and other professionals who specialise in dealing with WHS type matters. Over to you, Angela.
Thanks, Kerry. Good morning, everyone. Mario asked Liberty to illustrate how a claims incident response plan can help support a company and its officers when a regulator comes knocking. We recognise that the aftermath of any serious workplace safety incident can be really challenging for a company and its staff, but in the case of a workplace fatality, it can have long-lasting effects on the reputation of a company and now jail time for individuals. I think the best way to illustrate how an insurer can offer support through its claim service is with a hypothetical claims example. So let's go through this example together. A transport company in a small country town notifies us of an incident where one of their truck drivers has run off the highway and died as a result of the collision with a tree. The company is a major employer in a small town, and the driver involved is well known in the community. Local media have speculated that the brakes in the truck may have been faulty. The company performs all of its own maintenance. The press and the community are looking for an immediate answer about the maintenance of the truck. The regulator has issued a prohibition notice forcing all of the company's trucks to be taken off the road. Even though the company employs a full-time mechanic, the regulator wants to speak to the sole director owner immediately about the maintenance regime of all of the trucks. The police also commence an investigation. So, what type of support is offered through our claim service? Well, first and foremost, Liberty's claims incident response is focused on supporting the company when the regulator gets involved. We adopt an association claims approach where we work in partnership with the company and stay in regular contact throughout the claim until the matter is finalised. The role of a claim specialist is to engage in a transparent way with the company and add value through our existing claims experience, give clear guidance on how the claims process works, and have a proven framework in place for referrals to required specialists, ranging from public relations, legal, industry-specific experts to assist the company manage the crisis. Ideally, notification to your insurer should occur when self-reporting the serious injury or fatality to the regulator. This is a statutory obligation imposed on the company, as well as being a notification trigger under the policy. In the current claim scenario, the insurer was notified by the company the day after the accident with a link to a media article. This would be sufficient information for notification purposes. Other useful information from your insurer for your insurer includes any correspondence with the regulator and the internal incident documentation. As Kerry said, it's really critical to have the right support engaged early, since responses to an investigation and interview questions can be used later in any prosecution. So it's really important to notify early, engage your insurer, and seek specialist help. In the current claim scenario, the police and the regulator will urgently attend the site to secure evidence and then interview management. Specialist legal advisors are engaged from the outset of the investigation to protect the company's interests. Sometimes where the company has a pre-existing business relationship with a firm of lawyers who assist with their corporate business affairs, they often elect to appoint the same firm. This preference usually arises from familiarity and not necessarily WHS expertise. Liberty considers this step in the partnership really important. Expertise in the WHS field is quite specialist, and we want to ensure that the right representation is in place for all parties. The remote location of the transport company in the claim scenario may not have access to a specialist WHS lawyer in a small country town, so we would then make immediate arrangements for a specialist to be available. Cover is also available for counselling costs for those directly impacted by the injury or fatality and throughout the investigation process. The company will need to act quickly to gather as much evidence as possible and seek the appropriate advice regarding the causes of the incident. And at this stage, there's also a risk that the regulator will shut the site or a significant part of the site, and the company may need assistance on how to return to normal business operations as soon as possible. In response to our claim scenario, the policy would allow cover for the engagement of a public relations firm to manage reputational risk associated with the incident and negative media publicity. We have pre-existing relationships with public relations firms that have experience in managing this type of crisis exposure. A coverage assessment is communicated in a timely fashion so that the company has certainty of what is covered under the policy. In our claim scenario, we would advance defence costs immediately under the policy to the transport company, including any middle managerial employees and workers for legal costs associated with the police and regulator investigation. Separate legal representation would also be arranged and defence costs advanced to the mechanic during the investigations, given that he may have some personal culpability with respect to the maintenance of the vehicles. Separate representation is important given the conflict or the potential conflict of interest between the company and the mechanic. Soon after the incident, the regulator will issue notices legally compelling the company and witnesses to answer questions. The responses given are critical from a prosecution point of view. After that, the regulator will then seek to formally interview witnesses, and this usually includes management and directors. During the formal interview process, we recognise that this is a time of high stress, and Liberty expects that the appointed legal representatives are present throughout the interview process so that the company and individuals always feel supported and that their legal interests are being protected. After the interview process, a coronial inquiry may follow or a prosecution may commence. Generally speaking, defence cost expenses would continue to be funded under the policy until the conclusion of the matter, and that may look like a sentencing hearing. Some people might be wondering whether enforceable undertakings are available, but unfortunately they're not for industrial manslaughter charges. Overall, the claim scenario has illustrated that there are many moving parts and that all the steps taken immediately after the incident when dealing with the regulator are very, very important. These steps and the claim support framework in place will ultimately determine what outcome the company or individual might achieve in the prosecution, including whether or not a defence can be established for the charges. In the next slide, we take a look at our claims data. Before the changes to the WHS legislation for New South Wales businesses and the banning of insurance coverage for fines and penalties, Liberty analysed our claims data to work out what coverages under our WHS policy were being utilised the most. We reviewed 171 of our claims made over 4 years between 2016 and 2020. The analysis of the 4-year period, which is captured in the pie chart, shows us that the overwhelming coverage benefit is in the indemnities for investigation and defence cost coverage and not fines and penalties. The recommendation which Mario referred to earlier in the seminar in the Ballon Report at recommendation 26, prohibiting insurance cover for WHS fines and penalties was never intended to prevent a company from obtaining insurance coverage for legal costs incurred in responding to an investigation and defending a prosecution, and that's exactly what our policy does. The claims data supports this, and we anticipate these areas will continue to be the greatest areas of exposure. Cover is also available in the event that the company is required to pay the regulator's costs. Some other claims learnings in the WHS space include Victoria is by far the most active regulator in Australia, with 4 times more prosecutions being instituted against companies and workers than in New South Wales, according to publicly released data by the state regulators. The claims activity that Liberty is seeing by jurisdiction also supports this, with most of our WHS claims notified to us coming from Victoria, with Queensland coming in as a close second. This calendar year to date, Liberty has seen an increase in WHS policies bound by underwriters nationally compared to 2020. And our view is that significant cover is available under the policy and it remains an important risk management tool for companies. Thanks, Mario.
Thanks, Angela. I'll just wait for my camera to switch on. There we go. There's a couple of things that I think are important for the audience, and I think going back to Kerry's slides, the first things to note is around insurance is that there've always been exclusions in place around criminal convictions. So in many ways, the changes to the laws around the banning of insurance, in many ways, don't really change things too much, because the idea behind insurance is really to focus on defence costs and the like. And for anyone on the call that's been involved in a serious incident or a fatality investigation and the like, our experience always is, and my personal experience has always been that the biggest cost with regards to a really critical incident or a fatality always ends up being investigation costs, legal costs, and the like. And it's really important that we focus on that from a due diligence perspective, because I've worked with small businesses that have been prosecuted that weren't able to really defend themselves properly because they just couldn't afford it. And I even worked with one organisation that almost became insolvent as a natural result of the prosecution that they went through. So understanding the insurance part of things, even though as a health and safety professional, that's not my area of expertise, it's really, really important that we understand this. So we've got 5 minutes to go. We've got a couple of questions that have come through. I think the first one relates to Trent. So perhaps Trent, if you could just jump on. This question here relates to whether, based on your experience and based on what you're seeing, do you think that there's a risk that board members, senior executives, officers are becoming so risk averse as a result of these laws around personal liability that in many ways it's actually driving the wrong behaviours? They're becoming so conservative around decision making that they're either not making decisions at all, or they're becoming excessive in the way they expect reporting and data so that they can make the right decisions. What are you seeing in this regard?
Yeah, certainly we are seeing boards and executive leadership teams being relatively conservative. Obviously, the laws are intended to drive particular behaviour and to sheet home responsibility for work health and safety to the most senior officers. That is having, though, some impact on perhaps slowing decision making some businesses perhaps more risk averse than they were. I think the other thing to just sort of add, which is slightly off the question, but in New South Wales, before the laws changed in 2011, we did see, just because of prosecution activity, a significant chilling effect on people being willing to take up officer roles. We had a practice by regulators in New South Wales of regularly prosecuting in the mining industry mine managers where there was effectively deemed liability, and that led to a substantial chilling effect on individuals being willing to take up those roles. I must say, I think that would drive the wrong outcome if that was ultimately what is seen, if we get a range of prosecutions and convictions of senior officers under either the existing categories or under the industrial manslaughter categories. But I think the intention is to drive particular behaviour and for the responsibility around safety to be taken very seriously, but it can have the impact that you say, which is to require boards or senior leadership teams to ask for a lot of data, to be very conservative about their decision making, both in respect of when they take the decision and how long they take to make decisions. So the ability to be agile as a business in respect of safety can sometimes be impacted upon by these laws, I think.
Yeah, I think the trick is in all of this is for the safety manager or for those managing safety, it's about looking at these obligations as an opportunity for leadership and really focus on education, and then to try and manage the expectations around reporting in particular, where the amount of work that sometimes goes into developing leading indicators, for example, so that officers can make decisions. It may not look so, but in the background, there's an enormous amount of work that goes in reporting. So it's trying to strike a balance. But I must admit, personally, I've had some very good conversations with officers over the last couple of months, just off the back of these laws, because they are curious, and I think that's where the opportunity lies. It's really about using this narrative as an opportunity for us to perhaps have a different type of conversation that we weren't having a couple of years ago. And I think that's really the intent behind these laws. The other question, which we've just got a couple of minutes, and I think it's probably a combination for Trent and I, which is Trent mentioned in his slides a due diligence review, and what exactly does that look like? And I might even perhaps provide the first response, and Trent, I might get you to confirm or deny what I'm about to say. But a due diligence review, of course, will look very different for every organisation. For an organisation that's very mature, perhaps a very large organisation that has systems in place, the emphasis really needs to be around what are the obligations on the officers and what is happening across the business from a corporate governance perspective. So everything above the day-to-day side of safety. And that might be very different to perhaps a smaller business or a medium business, where the relationship between what the business owner does or the officer and what happens in the day-to-day management of the business at a shop floor level from a safety perspective, where they've got a much stronger correlation between that and what happens at a shop floor level, then that due diligence review and the action plan perhaps needs to be a bit more, as I refer to, nuts and bolts, because they've got such more influence over what happens at that level. So there's no real sort of silver bullet or standalone, this is what a due diligence review would look like, but you've really got to look at your specific organisation. If you're a very established, mature business, it needs to be a little bit different to if you're perhaps a less mature and a smaller business. It probably look a little bit different. What are your thoughts, Trent?
Yeah, I think on due diligence reviews or plans, it is worth thinking about the nature and size of business, as well as the maturity of it, how far along the safety journey are you along. The Hetherington case that I mentioned, it involved a relatively small business, but the way in which the prosecutor laid its charges does demonstrate how the courts will approach this, and that the regulators haven't quite got their minds as closely attuned to how to lay charges on officers ought to be. In that case, there was just so close similarity between what the PCBU was charged with and what the individual officer was charged with, that the charges were found to be defective. That is, it was effectively said that the officer needed to effectively do the same things as the business. Now, for very small businesses, that may be the reality, but for larger businesses, there's going to be a substantial difference between the due diligence of a board and a senior leadership team for a big organisation, and then what are the on-the-ground safety measures. So I think it is worthwhile as a business to go through some sort of analysis. A gap analysis is often a good way to go about it, and look at each of the 6 elements of the due diligence obligation, and perhaps even broader than that, knowing that the category of due diligence isn't just confined to those 6 elements, and look at what are the systems that the officers have in place at the moment. Are they satisfactory? What more could be done to be able to achieve due diligence? But as we've both said, that will depend upon the maturity, the size and the nature of the business.
Yeah, I agree entirely. So we've reached the end of the webinar. I'd like to thank each of the speakers for their contributions today, and I'd like to thank everyone for dialing in. We've covered off an enormous amount of content in the 60 minutes, but just some key conclusions or key things that we've sort of covered off. Obviously there's a lot to talk about in terms of industrial manslaughter and due diligence. There are variations and differences in the laws in the various states, so it's important to understand what they are. It's important to do a due diligence review and implement it, in particular developing an action plan, and to think broadly in terms of the relationship between what we've been talking about from a due diligence perspective and insurance. Now knowing a little bit about what those changes are in the laws with regards to insurance, just making sure that you've got the right coverage and making sure that you've considered it all, knowing that often having insurances would really assist with regards to ensure that you defend yourself appropriately should something terribly go wrong and you're facing some regulatory enforcement. So again, thank you very much for everyone for dialing in. Please provide us some feedback, and depending on the feedback, we may even be running a second webinar towards the end of the year, just so we can go into a bit more detail around what these due diligence obligations and these due diligence reviews would look like and how to prepare. But thank you again for your attention and dialing in, and we'll see you shortly. Thank you.